Communications, Law, and Journalism, and the director of the Tully Center for Free Speech at the Newhouse School at Syracuse University. It's a very long title, but he's doing this with Michael Grygiel, the co-chair of the Greenberg Traurig LLP's National Media and Entertainment Litigation Group. We're going to talk to you about just hot topics in media and First Amendment. Obviously, everyone seems to be muted, so I don't have to say mute if you're not talking, so that's good. And then I'll put it in the chat, but we're trying to just use a hashtag SPJR1C for any social media conversation that goes on. And we're using this same link for the 11 a.m. panel and then the noon panel. So, make sure you bookmark it. But that's it. I'll pass the baton to Roy, and you guys can dive in. And I'm sure there's a bunch of people starting to come in now.
Great. Chris, thank you. Thank you for all your work in organizing the conference. I know this has been a tremendous year for the region, for Region 1, and I'm really glad you stepped up and were able to put this together. Bill, thanks again for everything you've done. I believe by my math, this might be the 30th year I've been to an SPJ regional, and Bill, you were involved in the very first ones that I went to, so it's nice to continue to do this in many ways. I also want to thank my co-host here, Mike Grygiel from Greenberg Traurig in Albany. It's a national law firm. For those of you who are new to the area of media law, Michael is one of the country's top media lawyers and has a vast wealth of experience and knowledge that is going to be really valuable for our discussion. We're going to keep it fairly loose, so we'll make some general comments, talk about some contemporary hot topic cases, and hopefully get a little bit of a discussion and get some questions, and maybe we might even have some answers for your questions. So thanks for waking up early on a Saturday morning to talk about defamation and media law. So for some of us, this might be an introduction into some of these issues the legal issues that reporters and editors and publishers and broadcasters face. Some of this might be just a reintroduction for many of us. So we'll try to balance the basic with the more advanced, hopefully. And again, I apologize for my sound levels. My microphone is as good as it's going to get, I'm afraid. So I'll just try to talk a little louder. We're going to focus mostly on defamation, and that's always been in the background for everything we do as journalists, and it's always something you need to be concerned about. And if you pay any attention to hot topics and recent news, there's been kind of a resurgence of the issue over the last few years. And we can go back 4 or 5 years ago to when candidate Trump made his famous statement about recasting libel law to make it easier for people like him to sue the press and ostensibly punish the press for content they disagree with. It's interesting how this call to change and reform libel law is going to come back and possibly bite him as a libel defendant, but we might be able to talk a little about that. There have been some pretty high-profile cases we've seen with media defendants. We've seen Nick Sandmann, the MAGA hat kid in Washington, file close to $1 billion worth of claims against media defendants. Some of those cases are still pending. At least one of those cases is still pending. Down in New York City, the New York Times is currently facing a intriguing defamation claim by former vice presidential candidate and all-purpose public figure Sarah Palin. And this defamation case is emanating from an editorial of all things. So that's a hot topic. And every day for the last few months, we've been seeing news stories about the voting machine cases, Smartmatic and Dominion suing Fox, and just about everybody associated with broadcasts in the post-election fight over alleged voter fraud. So there are a number of cases that I think serve as a pretty important backdrop and pretty illustrative backdrop for us. And hopefully we'll explore a little more of that. Mike, would you like to talk about any specific case?
Yeah, sure. Good morning, everyone. It's nice to be here virtually with you all. And Roy, thank you for your kind introduction. I'm Mike Grygiel. I co-chair the Media and Entertainment Litigation Group at Greenberg Traurig. As much as I would love to talk about the Nick Sandman case, I am professionally constrained because I'm representing Gannett and USA Today in the case. But suffice to say, there are several interesting issues that may percolate as the case now proceeds into discovery. One of the points that Roy touched on, which I think is, I find interesting, is there does seem to be a resurgence of defamation claims over the past 5-6 years. And my own view is that there are a couple of structural reasons that account for that development. I think the first one is the pervasiveness and ubiquity of the internet. It used to be years ago with mostly print journalism, providing a great deal of the information that was received by the public. A story in a local newspaper was published, it went into the morgue the next day. It really didn't hang around that long. Of course, that's no longer the case. So my own thought is that the actual relative permanence of information and its accessibility on the internet has contributed to an upsurge in defamation claims. Number two, and this is a broader social and political observation, I think that the antipathy for the press, largely cultivated by the former president, also has a great deal to do with certain segments of society no longer being willing to give the press and journalists the benefit of the doubt. So in many ways, we are now, according to some people in the former administration, the enemies of the people. So those two elements, I think, have added fuel to the fire and tended to contribute to an upswing in defamation cases. One of the more interesting doctrinal developments that we're seeing is in a couple of decisions, the actual malice standard has been called into question, and its continued vitality has been placed out there in a couple of prominent opinions. Most recently, of course, perhaps most prominently by Justice Clarence Thomas of the Supreme Court, where in one of the Bill Cosby Me Too defamation cases, he dissented from a denial from cert and issued this long 16-page opinion saying actual malice really, was a judge-made doctrine. We should revisit it. He doesn't think that it should be a part of the First Amendment architecture that journalists have long relied on. And then about 3 weeks ago, a prominent judge in the federal appellate court in District of Columbia, Lawrence Silberman, joined the chorus. And in a decision that was decided on March 19th of this year, Judge Silberman, too, very strongly registered his concern that the time has come for, as he phrased it, New York Times v. Sullivan's actual malice standard to go. And I've highlighted a couple of his comments from the opinion, which are incredibly strong. And honestly, I never thought I would see the day as a First Amendment lawyer where this would be surfacing in our jurisprudence. But here's his description of New York Times. The holding has no relation to the text, history, or structure of the Constitution, and it baldly constitutionalized an area of law refined over centuries of common law adjudication. New considerations have arisen over the last 50 years that make the New York Times decision a threat to American democracy. So here you have a very prominent federal appellate jurist calling the New York Times v. Sullivan actual malice standard a threat to American democracy. Now, I would take serious issue with that. I would think it's a safeguard to American democracy, but there does seem to be in certain quarters of the federal judiciary this notion that maybe New York Times v. Sullivan extended too much protection to the press, and it's a doctrine whose time has perhaps come and gone, and in any event ought to be revisited. So I think that's a very provocative question and unsettling in many respects, and maybe something that we can put out to the group as to what people think about that, what your thoughts are, and where do we go from here? And what are the prospects? Is this a realistic development in First Amendment law that working journalists need to be concerned about, which is to say that the protection traditionally afforded by New York Times to coverage of public officials and public figures is something that maybe we may not be able to count on sometime in the future.
Sure. Let's take two steps back and really lay out at least what are the concerns for our reporters and publishers and editors and broadcasters. In other words, let's lay out the plaintiff's side of a defamation case, and then we'll dovetail into Times v. Sullivan, because I suspect maybe a few of us in the room aren't entirely familiar with that historic case. So when we talk about defamation, what are we really talking about? Mike, this is your bread and butter.
Sure. Well, I mean, there's several elements, but there's a great deal of commonality from jurisdiction to jurisdiction. So defamation has to be a false statement, for starters, of fact, not opinion, published to a third party that is not otherwise privileged and causes reputational harm or injury to the subject of the allegedly actionable statement. So there's several traditional elements bound up in the definition of what a defamation cause of action actually is.
And we're talking about entirely civil litigation, right? We're not talking about criminal issues.
Correct.
We're talking about civil. And this falls into what we call tort law, that is intended to apply monetary damages to repair some sort of harm. Mm-hmm. The harm we're dealing with here with these false statements of fact is harm to somebody's reputation. Mm-hmm. So I know, we're dealing with a number of different jurisdictions, and we're dealing with states that define this differently from state to state, but there are, as Mike said, there are commonalities. And
one of the basic elements that has come up in the voting fraud cases surfaced pretty strongly in a motion to dismiss that was filed by Rudy Giuliani. And I'm forgetting, honestly, whether he's the Dominion or the Smartmatic cases or both, but his motion to dismiss in one of them that was filed Thursday or Friday was to the effect that, following up on Roy's point, that defamation is traditionally conceived of as a harm to reputation. And therefore, it's somewhat ill-fitting as a vehicle for tort recovery when asserted by an inanimate corporate entity. And the thrust of Giuliani's motion to dismiss was that, in essence, under defamation law, there is a difference between individuals who can suffer reputational harm and companies, in that the only way a company can demonstrate actionable harm that's redressable in defamation law is by coming forward with proof of actual lost sales. So, and there actually is, I think, some sense to that. Damages in the defamation context has always been a difficult element to pin down. because the nature of reputational injury is somewhat inchoate. So the question is always, how do you quantify that? And with a company, again, an inanimate entity, the Giuliani motion says you need to plead actual economic harm, lost sales or otherwise. You fail to do that in the complaint. Therefore, you can't meet one of the elements, threshold elements of the defamation claim, and the complaint should be dismissed.
Right. So we've already broached the Times v. Sullivan case. Can we briefly summarize that, why that is important and relevant, and what that has done to the body of defamation law?
Sure. Sullivan was, of course, the landmark case from 1964 that arose out of the New York Times's publication of an ad that was placed by supporters and I think people who were involved in the civil rights protests in Alabama. And the ad was critical of local law enforcement efforts, and I believe Montgomery, Alabama, it may have been Mobile, for the tactics that were being deployed against the civil rights demonstrators and protesters. And after the ad was published, I believe it was the police commissioner of Montgomery, Alabama, that brought a defamation claim against the Times, although he was never named or identified in the ad itself. And in Alabama, when it went through the state court system, after it went to trial and after about a 2-hour jury deliberation, the Alabama local jury returned with a verdict of $500,000 against the New York Times, which at that point in time was a staggering amount. And historically, that led to numerous lawsuits being filed in southern state courts by local officials against largely northeastern media organizations for coverage critical of their handling of the civil rights movement. And I want to say at some point there were many, many millions of dollars in alleged damages that were pending in civil litigation defamation claims in southern courts, again, against largely northeastern media organizations. So this was a matter of significant concern. The New York Times appealed out of the Alabama state court system. It went up to the US Supreme Court, and they heard the case. And in flipping the verdict, in holding that the ad was protected by the First Amendment, the court announced for the first time what's known as the actual malice test, which is that where a plaintiff is a public official, as was the case in Sullivan itself, because Sullivan was a local county commissioner or a police chief or something like that, where the plaintiff in a defamation case is a public official, he or she has to prove publication with actual malice, which is one, knowledge in fact that the publication was false at the time it was disseminated, which should never happen with responsible journalist, the publication of a knowing falsehood, or two, publication with a reckless degree of entertainment of truth or falsity of the publication. And I didn't say that very well. In order to meet the second prong, there has to be a showing that at the time the journalist, the newspaper, the broadcaster entertained serious doubts in fact about the truth of what they were publishing or broadcasting. And this is a subjective standard. It depends exclusively on the state of mind of the journalist at the time the publication at issue was put out there. It has nothing whatsoever to do with the objective standard of professional newsroom practices or journalistic standards. So you could have a case with a serious departure from traditional norms governing journalistic news gathering and reporting, and that is not going to satisfy to show actual malice. So end of the day, it's a very speech protective standard that turns on the state of mind of the reporter and the editor who put out the story at the time it was published.
But actual malice does not mean intent or ill will or a vendetta out to get to somebody.
Absolutely not. And the case law is really clear about that. And that, of course, is a common misconception that at common law, one element of malice was ill will, bias, animus against another party, hatred. That is entirely divorced from actual malice in the New York Times v. Sullivan constitutional sense.
So if I'm a reporter and I misspell somebody's name, is that going to be actual malice?
I doubt it.
Right. So again, this gives us a little bit of wiggle room from a journalistic standpoint to even make mistakes, as long as they're, I mean, no mistake is a good mistake, but there's a little bit of flexibility with this standard. And it is often misunderstood, particularly by plaintiffs' lawyers who are trying to at least intimidate the press or maybe try to strong arm the press into some sort of payout or at least a correction or an apology, which wouldn't be too bad. Yeah. Going back to our main definition of defamation, Mike, you did say something that I thought was critical and interesting. You said unprivileged.
Mm-hmm.
What do we mean by privileged or unprivileged for our audience and for reporters in general?
Well, I mean, the typical source of a privilege, I suppose that most reporters encounter in their day-to-day work is what's known as the some jurisdictions call it the official proceedings privilege. Here in New York, it's known as the fair report privilege. And what that does is it confers fairly broad immunity on the press to report information from official government proceedings and or documents. So even if the information is false, if you have an official government record and you fairly and accurately report the information in that record as the basis of a news story, then you cannot be found liable in defamation for accurately reporting what's in the record, even if the information is incorrect. In other words, even if the government made a mistake. And some jurisdictions have gone so far, including New York and Massachusetts, to say, even if the reporter knows that the information in the government record is incorrect, as long as it's the government's error and not the reporter's, it's covered by the fair report privilege. So this is a terrific source of protection for the working press. It's premised on the theory that the public has the right and should be able to know in a robust way what the operations and activities and decision-making of government is at all levels. And therefore, we are going to confer a privilege on the press to report on government conduct as sourced from official government records. And another twist on this doctrine is whether or not it applies to non-public government records that might be leaked to a source. And there's actually a split in authority from jurisdiction to jurisdictions. Certain jurisdictions like New York and Massachusetts say, we don't care even if it's leaked, even if the press isn't supposed to have it in the first instance. As long as you fairly and accurately report the information, you're going to qualify for protection under the privilege. Other jurisdictions have not gone quite that far in recognizing the scope of protection afforded by the privilege.
So, I mean, one of the things that I like to tell students and just about anybody who listen is, your legal defense really begins at the front end, when you're doing your reporting, when you're doing your gathering, your fact gathering, your collection, your writing, your editing, your post-production. And you know, by the time somebody's threatening to sue you, that's a whole different scenario. But one of the things that you know, that I always think that reporters need to do is ask the tough questions, but also try to back things up with official reports. And from an editing standpoint, I think one of the greatest questions that any editor can ask is, how do you know this, and what's your basis for something? So again, we're all on strict deadlines, and you know, the deadlines now are minute to minute, but the same standards would apply, that, you know, for breaking news as it would for, you know, a long-term investigative piece. So again, our defense begins at the beginning.
Yep.
I think this might be a good opportunity to open it up to questions, or we can just keep talking. But I'd be happy to start to field questions. If you want to just engage microphone and camera, that's fine. If you want to put them in chats, I guess that would be fine too. Yes, Erwin.
Yeah, Roy, I was just wondering if maybe you'd want to talk a little bit about the cases involving Smartmatic and Dominion. I mean, it seems to me that under any standard, the media defendants in that case are at greater risk because of, you know, what they're alleged to have done and said about those companies.
Sure. I've been spending a lot of time thinking about these cases for the last few months. So again, going back in the post-election haze, we had Fox in particular and some other news outlets channeling questions about the veracity of the voting, and two of the companies that handled the voting machines, Smartmatic and Dominion, are at the center of this. And these two companies are engaged in separate litigation. One is in New York State Court down in New York City. The other is in federal court in Washington, D.C. And these are literally billion-dollar claims, claiming that false statements questioning the veracity of the voting figures, allegations of links to Venezuelan dictators and other questionable entities offshore have inspired the two companies to file a series of separate defamation claims, and both are pleading that these statements were published with actual malice. Now, the interesting thing is there are multiple defendants, including the actual speakers, Giuliani, Sidney Powell, the MyPillow guy, all these people who have gone on TV and raised questions and made accusations. Fox is also a defendant, in particular, some of their main television personalities, Lou Dobbs, Maria Bartiromo, and Judge Janine Pirro. And there are questions whether they were making false statements or whether the venue was allowing speakers to go on and make false statements that were not being challenged or rebutted. So that's kind of a thumbnail. Right now, it's in pretrial phase. Fox filed a pretty interesting motion to dismiss. Fox is asking the court to throw out the case because they're claiming that there's their First Amendment values, that it was a discussion of political issues, and that's First Amendment protected speech. and that there was pure opinion in some of the speakers. So it's kind of fascinating. Sidney Powell filed a motion to dismiss on a couple of days ago on some procedural grounds, and Giuliani is filing on procedural grounds too. So it's a fascinating series of cases. Mike, did I leave anything out on that?
No, I think you're actually more conversant with those cases than I am, Roy, but I do have a couple of observations and then a question. First, just for the benefit of the group, both in the Dominion and Smartmatic cases, the plaintiffs, the voting companies, and I believe there's a couple of individual plaintiffs as well who are officials or owners of the companies. They are represented by very serious, capable, competent lawyers and law firms. Extremely well-qualified representation. So I think that alone raises the seriousness of the cases up a little bit. These are not law firms that are going to be undermanned or underwomaned or understaffed, and they know what they're doing. Second, there seems to be a prevailing assumption that the companies qualify as public figures for purposes of the First Amendment in bringing these claims. I'm not so sanguine about indulging that, at least at this point. I think merely because of the fact that a company contracts with or does business with the government, I'm not sure that is sufficient to elevate them for constitutional purposes out of the box of private figure plaintiff into public figure plaintiff. But I guess that remains to be seen. Third, and here's my question, and I'll throw it to you, Roy, and also see if anybody else wants to weigh in on this. Is there a difference here in the liability exposure of someone like Sidney Powell and Rudy Giuliani over and against the Fox network and its personalities?
Yeah, that's a really good question. And I would think that there would be more liability, more exposure for the actual speakers over the broadcasters, and less of a First Amendment defense. I think we're going to see a fairly robust analysis of whether Fox has any sort of First Amendment protection for providing a platform for speakers. Now, let's take the politics out of it. Let's say, a random speaker live on the air, for illustration purposes, calls me out and says, this Gutterman guy at Syracuse embezzles funds and does cruel things to animals, right? I would think a speaker in that situation would have liability, and perhaps a broadcaster might have some liability for putting that on without vetting it or even rebutting it. Again, the context is so critical to much of this, and I think I want to use the context element here to sort of bring in one of the questions from the chat too, because one of our members here asked, how do we determine malice? How is malice, particularly actual malice, determined? Right? How do you prove somebody published or broadcast or posted something that they either knew was false or with reckless disregard? How is that ascertained? Mike, it's
a great question, and thankfully it's with difficulty. And typically, of course, you're never going to have direct evidence of actual malice. You're not going to have, unless it's a Jason Blair type of situation where a reporter made stuff up. You're never going to be able to establish the knowing falsity element. So it's always going to turn on the subjective state of mind of the reporters and the editors at the time something was published. And then the question distills further to how does that get proven as a matter of proof, so a judge can let it go to a jury and let a jury weigh the evidence. Well, Again, the way that is likely to happen is through inferences drawn through objective proof. And I always, as sort of a baseline, I go back and I look at after a couple of years after the Sullivan case, the Supreme Court issued this case called St. Amont v. Thompson. And it provided 3 examples which have more or less become reliable benchmarks for what might suffice to prove actual malice. And there's 3 categories. Number 1 is where a story is fabricated. So again, you're in Jason Blair territory there, highly unlikely to ever happen with a responsible journalist and news organization, or is based on a unverified anonymous telephone call. So, again, that's a pretty extreme example. If somebody calls up a reporter and says, I know the mayor of Syracuse committed animal cruelty and did something horrendous last night, you're clearly not going to publish that or go on the air without some additional news gathering and reporting legwork. The next category is when the allegations are so inherently improbable that only a reckless man would have put them in circulation. Now, maybe you can make an argument here that with the Fox stuff, that the voting fraud claims have been so pervasively discredited that broadcasting them was inherently, they were inherently improbable for purposes of this category of actual malice. And the third is that where there are obvious reasons to doubt the basis of the story. So assuming the applicability of the actual malice standard in the voting fraud cases, I can see that having some traction as well. But those are kind of the 3 or 4 boxes that if you're a plaintiff's lawyer in a defamation case, where you're looking to steer the proof.
And proof can be ascertained through pretrial discovery. What can be turned over in something like this?
Reporters' notes, emails, drafts of, if it's a news story, drafts to look at how things change, which of course became a prominent element of the Sarah Palin v. New York Times case, when there was hyper-technical parsing in the discovery that was allowed of revisions made to the editorial after it was originally submitted to James Bennett and what he did with it. Today, email, of course, and contemporaneous exchanges are going to be a huge element of discovery in any significant defamation case, as I would expect they will be in all of these voting fraud cases.
Yeah, and possibly memos exchanged, planning memos, editors' notes, recordings. Can recordings be turned over?
Sure,
Yeah.
Absolutely.
Yeah. So, what you leave out of a story, if that ends up being something that is argued, can be ascertained through the video or audio that you don't use. So I guess that raises the next question. Well, what do you do with your recordings? Do you get rid of everything? Do you get rid of your notes? That might be actually a different question. So Mike, what's your advice on record keeping or document keeping?
Well, my advice on that point, Roy, is do have a practice that you consistently follow and then follow it. So if you hang on to your notes for 6 months or some specified period of time, I would then say, fine, it's okay to get rid of them according to some sort of interval that you may have. If your news organization has a different practice, by all means, comply with your employers or the company you're working for, whatever their internal practices and procedures are. The one highlight here, the red flag item, is once you have noticed that a story is being challenged, at that point, you certainly don't want to get rid of your notes or anything, your emails, because in a worst case scenario, that could give rise to an inference that you were trying to hide something or conceal something. And today, of course, as soon as you get a lawyer's letter from a potential plaintiff raising a fuss or calling into question a certain publication or broadcast, at that point, typically most companies send out a litigation hold notice. So to anyone who worked on the story saying, hang on to what you have. At this point forward, we'll put a lock on your emails. Nothing gets overridden, nothing gets thrown out, nothing gets destroyed, because you don't want to be in a position down the road if the case does become the subject of a complaint, that you're in a position of somehow getting rid of evidence after you were on knowledge that the story or the publication was being challenged. That's the one position a journalist does not want herself or himself to be in.
Sure. What role do corrections play in any of this? I mean, nowadays with everything digital, you can fix things, right a minute after you make the mistake, but it's still going to be somewhere. What kind of inference can we draw from corrections or anything like that?
Well, I mean, the publication of a correction is not in any way regarded under the actual malice case law as proof of constitutional fault, because it took place after the fact. So it doesn't speak to the state of mind at the time of publication, which governs the New York Times v. Sullivan actual malice inquiry. My view about corrections is that if, in fact, a news report is in error and you have discovered the error, then you should publish a correction. It is what it is. If you make a mistake, correct the record. In New York Times v. Sullivan itself, there were factual inaccuracies in the original ad, and the Times did publish a correction. So if you're wrong, put it out there. One caveat to that is make sure if you publish a correction that the correction is correct. You don't want to, you have to do a little bit more investigating sometimes to publish a correction, but make sure that when you publish the correction, you don't want to compound the original error by making another one.
Yeah. All right, I see we have 1 minute left. Anyone else have any questions that they'd like to throw out here? Okay. Let's give a walk-off. Mike, 30-second primer walk-off.
Well, I think I'm really waiting to see what happens in the Palin v. New York Times case, because the Second Circuit Court of Appeals, I think, misapplied the New York Times v. Sullivan actual malice standard in that case. Honestly, I never regarded Palin's claim as a serious defamation claim, unlike the voting cases, the voting machine company cases, which I do think are serious. And it's actually astonishing to me that this case is going to go to a jury. So we will have to see what happens, and it's scheduled to go sometime in June of this year. And that will be very interesting. And I'm sure there will be appeals from both sides, depending on what happens. And then two, I'm interested to see how this questioning in the federal judiciary of the ongoing vitality of New York Times v. Sullivan plays out. I'm an optimist on that point. I like to think that in Supreme Court terms, the glass is probably 8/9 full. But we'll see. There does seem to be a little bit of a groundswell among federal judges of the conservative Federalist Society stripe that New York Times v. Sullivan has gone too far and conferred too much First Amendment protection on the press. So that seems to be an issue that merits further watching.
I agree on that. And we did have a question in the chat about special considerations for photojournalists. That could be a whole separate discussion. Photojournalists are subject to defamation issues. We've seen a couple of high-profile cases of misidentification in photos. right clicks with linking to the wrong people, things like that, which have given rise to defamation claims as well. But maybe that's a discussion for another day. Again, I can field some questions here and there. I'm available at rsgutter@syr.edu. I'll put this in the chat here at Syracuse. And I appreciate all your time this morning, Michael. It was always a pleasure working with you.
Oh, thanks, Roy. I hope it was helpful for people.
Great. And everybody enjoy the rest of the conference. We'll see you at the next session. Okay.
Thanks, Roy. We have a break now till 12 minutes until 11 o'clock.
Sure. All right. Well done. Pulled it off. I don't know how everybody was able to pull this one off, but good job.
Hopefully it's a one-off.
Yeah. Well, sounds like it's been a crazy year for the region anyway.
Yes. Much saner now. Isn't it?
Yeah, pretty wild. So, all right. Well, I'm going to take a break and maybe pull back for the next one. I'll see you in a few.
Yes. And Roy, start planning for Hofstra next year.
Next year on Long Island. I'm happy to be there.
Okay. You're a fixture. We want to keep that going.
Wonderful. Looking forward to it. Okay. We'll be in touch, Bill.
Great. Thanks, Roy.